As a country, we have to come to a place of acceptance to the effect that as long as a marriage is not formalized, as long as a marriage is not registered, then that particular marriage does not exist, never existed, will never exist, and there is no point trying to prove otherwise. Why I say so is because if there are cases wherein people are losing out badly in court these days, is when it comes to proving the existence of marriage. Lawyers are making their submissions, which are very much informed, well-researched. People are bringing witnesses just to prove that so-and-so live together as husband and wife, but it is still not enough. You see, gone are the days when the courts in this country used to apply the doctrine of presumption of marriage. The idea was very simple. As long as a man and a woman lived together for a very long time and they had children together, then it was presumed a marriage existed, even in instances when there was no formal registration. Case in point, 4 years ago, the Supreme Court issued a warning that the doctrine of presumption of marriage was an exception and not a default rule. It was not automatic that because two people have lived together for a very long time, then that doctrine was going to be successfully invoked. And indirectly, this court actually encouraged Kenyans to consider formalizing their marriages. If it is a customary marriage, then there is need to register it within the statutory limitation. And if it is any other type of marriage, then it needs to be registered as per the laid down procedure in law. The Court of Appeal amplified the position of the Supreme Court, and it stated in even more clearer terms that the doctrine of presumption of marriage is on its deathbed. This means courts in this country will no longer, or rather they are not willing to continue applying this doctrine in instances when a party runs to it trying to prove the existence of marriage, but they do not have evidence that indeed there was a clear mutual intention by both parties to enter that particular marriage. And the Court of Appeal said categorically clear that cohabiting, staying together with another party for a very long time, even decades, is not sufficient proof of marriage. Bearing children and even raising them to post-adulthood, several children, it's still not sufficient proof that a marriage existed. Even claims of customary marriage are failing terribly because now the law requires that all customary marriages ought to be formalized. And while doing this, one needs to prove the customary law that was applied in that particular ceremony. One needs to prove that indeed some traditional rites were performed and that people were there to witness that particular customary marriage. So where this leaves us is unless you have formalized your marriage, unless you have taken that decision to put pen to paper and categorically show that the two of you have an intention to be tied down in marriage, then chances of that particular marriage surviving the test of the law are so low.